Hello, hello. Good afternoon, good morning. How is everyone today? Happy Thursday. It's Thirsty Thursday. Who's thirsty today? Well, good luck with that, Denitra. Good luck. Okay, my internet is acting a little unstable. Thank you. I just noticed it, so. Good morning. I am Queen Newton. Oh, yeah, y'all need a lot of luck. A lot of luck. Prayers. Yeah, I mean, that's the best you guys can do, right? As supporters, is pray, and stick together. That's the best you can do. I mean, you really can't do anything for him. In reality, in all reality, you know, his supporters really can't do anything but stand on the sidelines, be good, and pray for him. That's the best thing that you really could do. Hey, Service P. Yeah, the girls told their truth. All the witnesses told their truth. He got convicted on 9 counts in New York. And in Chicago, he'll probably be convicted of 13. So, like I said, prayers up for him, right? That's the best you guys can do. That's it, that's all. How do you know they lied? How do you know they lied? I mean, like, were you actually there in these time zones when all these things happened? No, nobody was there except for the girls, the man, the people that were in that circle, and people that knew, and God. That's it. Us as spectators watching, we're just watching the story unfold. And of course, we know that there's a lot of lies on Rkelly's part because everybody keeps trying to cover up for him. Everybody's trying to spin all these narratives. And there's more than one person that came out against him to speak up about him, to speak for the actions that they know that this man has done. Whether they seen it or whether they heard it, they corroborated stories. Hey, Jade. Hey, Bev. I don't know who Maximilian is. I really don't care. I mean, unless Maximilian is Rkelly himself, can't nobody speak up for Rkelly except for Rkelly. Thank you, Jade. Just for that, you get a wrench, babe. Thank you, I am Queen Newton. Exactly. That is very true. That is facts. That is facts. We wouldn't be here if Rkelly would just come clean and stop his lying. If he would have came clean back in 1991, 92, 93, 94, when they found out about him, if the parents of Aaliyah would have stepped forward, if the parents of Tiffany Hawkins would have stepped forward and made a big thing, he would have stopped many, many years ago. And yes, we would not be here today. But who knows? because he could have done jail time back then, up to 15 years he was facing. Came out in 10. He could have either stopped, learned his lesson, got the help he needed, or he would have came back out into the streets to do the same exact thing. And we would be right back here where we are today. That's a decision he had to make. And he made his decision when he made his bed and he lay down in it. Hey, Mom Life. You welcome. So I'm going to share this video with y'all. I'm going to go on mute. And then we will begin to read.
The New York trial against disgraced singer Rkelly, it may be over, but his Chicago trial just got its official start date, and we have that for you. A federal judge has ordered him to stand trial in Chicago beginning of August 1st of next year, 2022. He's facing child pornography and obstruction of justice charges.
Hey, Andrew. Hey, just 504 girl. What's up? So, what we have here is a memorandum, as we know, a memo that Judge Donnelly wrote to explain her decision and her order as to Rkelly's conviction and what happened during trial. Yes, they might take his Grammys away, but they said they haven't made the decision as of yet. I guess what they'll probably be waiting for is to see after his sentencing, and then maybe they'll strip him of his Grammys, because that's a really big accomplishment. That's just like having your star on the Hollywood Walk of Fame, right? When something happens, they usually strip the star away and they take the star. So, you know, he did this to himself. At the end of the day, he did this to himself. Point blank, period. So as I said, this is a memo about her decision and the order that she made, as opposed to what happened at the trial. Now I'm going to go off camera, so I'm not going to be able to see you guys.
They have the same.
And it says, Ann Donnelly, United States District Judge. The defendant was charged with racketeering in violation of 18 U.S.C. 1962 C and 1963, 3 counts of Mann Act transportation to engage in illegal sexual activity in violation of the 18 U.S.C. 2421A, 3 counts of Mann Act coercion and enticement to engage in illegal sexual activity in violation, Papi, bring me juice, in violation of 18 U.S. 2422A, and 1 count of Mann Act coercion of a minor to engage in illegal sexual activity in violation of 18 U.S.C. 2422B, and 1 count of Mann Act transportation of a minor with intent to engage in illegal sexual activity in violation of 18 U.S.C. 2423A. And then they put in a motion, number 43, on September 27th, 2021, the jury convicted the defendant of all counts. And then it says the trial transcript and location is 4765. That's the page. And through 4773. Thank you, baby. Now, in February and March of 2020, the defendant moved to dismiss count 1 of the indictment, and the counts of the indictment incorporating New York Public Health Law, Section 2307. And then they put documents numbers 41 and 42. Now, she says that I denied the motion. She denied that motion because they wanted to dismiss that motion. Now, she denied it. Then she mentions another document, number 69. On the morning of jury selection, the defendant filed a second motion to dismiss the indictment, making some of the same arguments he made in the first motion. Then, in another motion, document number 159, the government opposed, which means the prosecutors opposed their motion. And then there was another document that was put in, and that's document number 168. And that one, she says, I denied the motion on August 18th of 2021. And she said, the trial transcripts, number 4. So that's page 4. This opinion sets forth the basis for that decision. And over here she says that in the second motion, the defendant sought dismissal of the entire indictment. He just wanted to just throw it all away. And she denied it. Then she talks about the background. Now, her opinion is set forth on the basis for that decision. Now, she's going to speak about the background. This is based on her decision. These are the reasons why she denied certain things. Okay? Talking about the background. The third superseding indictment returned on March 12th of 2020, and it charged the defendant with racketeering and violations of the Mann Act. And then she explains another motion, motion number 43. And specifically, so this motion is specifically talked about the violations of the Mann Act and racketeering and what he was charged with. Okay? And it was March 12, 2020, the third superseding indictment. She said, and as is relevant to the motion to dismiss. Now she said 2 of the racketeering acts, Racketeering Acts 12 and 14, and 4 of the Mann Act counts. Now, this is what they were requesting to dismiss. and that and the 4 of the Mann Act counts, which are counts 6 through 9, and it included allegations that the defendant had sexual intercourse with Jane Doe number 6 in violation of section 120.20 of the New York Penal Law, which is reckless endangerment in the second degree, and section 2307 of the New York Public Health Law, which prohibits someone who knows that he has an infectious venereal disease from having sexual intercourse with another person. Now, the indictment alleged that the defendant engaged in unprotected sexual intercourse with Jane Doe number 6 without first informing her that he had contracted herpes and obtaining her consent to sexual intercourse in these circumstances. And then it says certain paragraphs 34, 33 and 34, 37, 38, and 43 and 46. Now, Racketeering Act 1 charged that the defendant, together with others, bribed a public employee on or about August 30th of 1994 in violation of the Illinois Criminal Code section 5/33-1A and 5/5/5/1. And it's to paragraph number 13. Racketeering Act 3 charged that the defendant, together with others, confined Jane Doe number 3 against her will in or about and between 2003 and 2004 in violation of Illinois Criminal Code section 5/10-1 and 5/5-1, paragraph 15. 3 of the Racketeering Acts charged, Racketeering Acts 2, 7, and 10, accused the defendant of inducing a minor to engage in sexual explicit conduct for the purpose of producing one or more visual depictions of such conduct. So Racketeering Acts 2, 7, and 10 had to deal with inducing a minor to engage in sexual explicit conduct, to make child pornography. How about that? Isn't that special? And that's in paragraphs 14, 21, and 30. Then she says that in the discussion that the defendant raised 3 challenges to the 3rd superseding indictment. First, he argued that the PHL section 2307 and the CPL section 120.20 charges should have been dismissed on the theory that the government could not prove the elements as a matter of law. Now, the defendant contended that dismissing these charges would make venue inappropriate in the Eastern District of New York, and that the indictment should have been dismissed accordingly. Motion number 159 at 5 through 10. Next, the defendant argued that Racketeering Acts 1 and 3 should have been dismissed because they were untimely under Illinois state statutes of limitations. And the motion for that one was 159 at number 11, page 11. Now, third is that the defendant claimed that Racketeering Acts 2, 7, and 10, which charged the defendant with coercing a minor to create child pornography, should have been dismissed because there was no evidence that visual depictions existed. And that's at page 12. Now, Racketeering Acts 12 and 14 and counts 6 through 9. The defendant moved to dismiss Racketeering Acts 12 and 14, as well as counts 6 through 9. Now, these counts charged that the defendant violated the Mann Act when he engaged in unprotected sexual intercourse with Jane Doe number 6 without first informing her, and that he had contracted herpes, and obtaining her consent to sexual intercourse in these circumstances in violation of PHL section 2307 and CPL section 120.20. Paragraphs 43, motion number 43, paragraph 33 through 34, 37, 38, 43, and 46. Now, in this subparagraph here, it talks about what he had claimed. The defendant filed it on August 9th, the motion to dismiss, that it was timely. So it talks about, it says, it is not clear that this second motion to dismiss was timely. Now, the defendant filed it on August 9th, 2021, after prospective jurors completed the questionnaires, and on the morning that questioning of individual prospective jurors began. So the Federal Rule of Criminal Procedure, as to 12B and 3, it requires certain motions to be raised pre-trial. Motions that fall under 12B3 include claims of improper venue and defects in the indictment, according to Federal Rule Criminal P 12B and 3, Rule 12C and 3. It provides that if a party does not meet the deadline for making a Rule 12B and 3 motion, the motion is untimely. Now, the defendant's attempt to evade this result by styling his motion as a 12B2 motion, not to subject to 12C3, is not persuasive. Now, the arguments in this motion, which are discussed in detail in the sections below, clearly fall within 12B3. So, nor did the defendant establish good cause for the tardy filing. Indeed, the defendant moved to dismiss many of the same charges more than a year and a half before filing this motion. And you can see motion number 41 and 42. So in other words, they were late filing a motion. And anyway, they already had filed the motion a year and a half ago. Now it says that the defendant argued that pretrial dismissal was warranted because, as a matter of law, the government could not establish that the defendant violated either state statute. So this argument is unavailing for the reasons explained below. Thus, the venue challenge also fails. PHL Section 2307 prohibits someone who knows that he has an infectious venereal disease from having sexual intercourse with another person. Now, the indictment charged that the defendant had sexual intercourse with Jane Doe number 6 without informing her that he had herpes or obtaining her consent to have sexual intercourse in those circumstances. And it speaks about it in motion number 43, paragraph 32 and 34, 37, 38, and 43 to 46. Now, according to the defendant, herpes is not a venereal disease within the meaning of the statute. And they talked about that in motion number 159 at numbers 5 through 8. And this argument, she said, is not persuasive because the language of the PHL 2307 is unambiguous. And it provides that any person who, knowing himself or herself to be infected with an infectious venereal disease, has sexual intercourse with another shall be guilty of a misdemeanor. Now, herpes falls within the statute's plain terms. And it recites C. People X. Rel. Negron versus Superintendent, Woodburn Correctional Facility, 36 NY 3D 32 36 2020. And quoting a State of New York versus Patricia the Second, 6 NY 3D 160 162 2006 case law. Now, in this case laws, it says where the language of the statute is clear and unambiguous, courts must give effect to its plain meaning. Now, the courts, it says, construe words of ordinary import with their usual and commonly understood meanings. And dictionary definitions are useful guideposts in determining the meaning of a word or phrase. And it cites another case law, and this is a 2019 case law. And then it recites another one, another 2019, explaining that using the Merriam-Webster's Colgate Dictionary and Black's Law Dictionary to interpret a state statute, venereal disease is just an antiquated term for sexually transmitted disease. So see venereal disease, it'll say sexually transmitted disease. Black's Law Dictionary, 11th edition, 2019. The entry for venereal disease says see sexually transmitted disease, which in turn is defined as a disease transmitted only or chiefly by engaging in sexual acts with an infected person, and also termed venereal disease. So the emphasis is in original. So the Merriam-Webster likewise defines that venereal disease as a contagious disease, such as gonorrhea or syphilis, that is typically acquired in sexual intercourse. Now, venereal disease in the Merriam-Webster.com dictionary, okay, and last visited October 25th, 2021, so it's updated. It says that general herpes is one such disease, and that the Centers for Disease Control defines general herpes as a common sexual transmitted disease, STD, that any sexual activity, that any sexual active person can get. Then it states about general herpes in the CDC fact sheet. And it states that, moreover, New York courts have found that PHL section 2307 includes herpes. See a case law in 1986 where finding a duty to disclose general herpes based on PHL section 2307, and then it talks about another case law, and it's the same thing, which means finding a duty to disclose general herpes based on that law. And it's to, she says, to support a narrower reading of the statute. The defendant cited not case law, but a statement by the New York Department of Health, Public Health, and Health Planning Council about a proposed, now adopted, amended to include HIV in the conditions that constitute the definition of sexually transmitted disease for the purpose of certain sections of the public health law. Wait a minute. So Judge Donnelly made her decision based on the fact that instead of them reciting, because they were supposed to recite a case law that is matching what they're saying, you know, that herpes is not really a sexually transmitted disease because it's very common. So instead of them finding a case law that talks about that, they decided to add articles as fact sheets of case law instead of using an actual case law. So she said, these guys are a whole bunch of idiots. They're trying to give me some goddamn articles to read. No, you got to find me a case law that matches your statement to fight this off. And being that you didn't, I deny. That's exactly what she did. You can't come and tell me with some bullshit article. I don't want articles. I want law. This is what we're fighting. Law, not articles. I don't care about this. But since you want to bring it up, according to the article, okay. She's like, no matter what, it still says that herpes is an STD. So, bye. Wow. So she says, some commenters expressed concern that the proposed regulation could have the effect of making it a misdemeanor under PHL, which is a law, 2307 for HIV positive individuals to have sexual intercourse in some circumstances. And then she says something else, and it comments that, and responses on proposed amendment to Title 10 of the official completion of codes, rules, and regulations of the state of New York, section 23.1 and 23.2, May 18th of 2016. And it has a whole bunch of blah, blah, blah. Then it says that the agency responded that it interprets the law as only applying to individuals who knowingly expose other individuals to acute bacterial venereal disease such as syphilis or gonorrhea. Now, the agency's response says nothing about herpes. The agency was not asked to and did not express a view about herpes, nor does the statement overcome the plain meaning of venereal disease. So the statutory language is unambiguous and the court need not look beyond the plain meaning of the statute's term. Who's freeing Rkelly? He ain't going nowhere. Hey, Diva Time. Happy birthday. Everybody, please say happy birthday to our sister Diva Time. Her birthday was yesterday. We're going to throw a party for her Tuesday. Right, baby? I believe it was Tuesday. I'm going to try to set it up for Tuesday. Hello, Sharice. Hey, Sidbo. Hey, James. Hey, Nicole, Mama. No. Did I just delete his message? What did I do that for? Oh, no, my phone is getting stuck. I am so sorry, James. I got to get a new phone, guys. I got to get a new phone. I didn't mean to delete your message, Puppy. Did I hide them? What did I do, guys? Oh, my God, now I timed them out. Okay, no. I can't scroll on my phone because I'm trying to scroll and it's making me do all these other things. All right, James, I'm sorry. I timed you out. I don't know how to. Oh, no. All right, Puppy. I'm sorry, baby. You're going to have to wait like 5 minutes. My bad, Pa. Yeah, I know. I didn't mean to. I went to scroll and it did whatever it wanted to do. Oh, Lord. I got to get a new phone, guys. I'm coming down to desperation because it's doing whatever the hell it wants to do. Like I'll press something to scroll, and instead of me scrolling, it'll open up something I didn't want to open. Or touch something I didn't want to touch. It's crazy. Hey, D-Live. What's up, Mama? Ta. So, okay. So now, in this part, she explains about the CPL, section 120.20. And she says that in addition to charging violation of the PHL, section 2307, Racketeering Acts 12 and 14, and 4 of the Mann Act counts charge that the defendant violated the New York Penal Law, section 120.20, which provides that a person is guilty of reckless endangerment in the second degree when he or she recklessly engage in conduct which creates a substantial risk of serious personal injury to another person. So this is why they say that he got charged with personal injury, because it says serious physical injury is a physical injury which creates a substantial risk of death or which causes death or serious and protracted disfigurement or protracted impairment of health or protracted loss or impairment of the function of any bodily organ. So being that he messed her up and gave her herpes in the mouth, he gave her serious physical injury. She could break out and have all this stuff disfigure her face, her lips. And if she's got it venereally, right, as well, right? So she got it venereally as well, then she's also in serious physical injury down there as well. Hello? Okay, wrong number. So now it says that the defendant maintained that this charge is a factual impossibility because adult consensual intercourse usually does not lead to a serious physical injury, which would create a risk of death. Is he was his lawyers really serious? That's what they were saying? That this is factually impossible because an adult can consent when it's consensual intercourse, she can't get sick. Did y'all hear that? Did y'all understand that sentence? Said Bo, 1-800 personal injury attorneys at law. Oh, from being a groupie. Oh my God. Well, so says that it's a protracted loss or impairment of the function of any bodily organ. So if, for example, one participant does not inform the other that he has a sexually transmitted disease, or she, that the defendant was charged with doing exactly that. Having sexual intercourse with another person while he knew but did not disclose that he had a sexually transmitted disease. So there was a motion put in, number 43. Again, same sites, paragraphs 33 through 34, 37 to 38, 43 and 46. Those are the lines. And it says that moreover, serious physical injury under the statute need not create a risk of health. So as the statute clearly says, serious physical injury also includes serious and protracted disfigurement, protracted impairment. You know, when Rkelly was like, when he said to Azriel, oh, you got the herpes? Okay, well, you know what? No, it's not that. You're all right. You know what? It's just that your pussy's broken. Serious and protracted disfigurement, protracted impairment of health or protracted loss or impairment of the function of any bodily organ, whether it be your lips. Well, organs are, no. You know, your puna needs an organ in there. Okay. So then it says that the New York penal law, New York courts applying the reckless endangerment statute have determined that infecting someone with a sexually transmitted disease without prior disclosure can lead to criminal liability under the statute. And it cites a case, People versus Williams. And then it says the defendant cited People versus Santola. Now, in this case, a vehicular assault case, as support for his claim that the conduct alleged in the indictment was not reckless. And that's in motion 159 at lines 9 through 10, citing 61, miscellaneous 3D 1205A, subcourt 2018. Now, Santola is entirely different. They cited the wrong law. The defense team cited the wrong law. The Santola case is totally different. It says that the Centola case was alleged to have driven his truck into a pedestrian so slowly that the collision merely pushed the victim and made him stumble. And it says that the court determined that Centola's conduct was ill-advised, unwise, and imprudent, but that there did not appear to be any reasonable evaluation of the facts, which would lead to the conclusion that because of the actions of the defendant, the victim was in danger of a substantial risk of death, or that the defendant's actions could cause death or serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. Now, those facts have nothing to do with this case. In short, a person who has sexual intercourse with another, knowing but neither disclosing that he or she has a sexually transmitted disease, nor obtaining his or her partner's consent, exposes that person to a protracted health impairment, the sexually transmitted disease. Now, the defendant also argued that the indictment did not allege the defendant caused serious physical injury. Racketeering Acts 12 and 14, as well as counts 6 through 9, were pled properly. An indictment need do little more than to track the language of the statute charged and state the time and place in approximate terms of the alleged crime. Then it cites another case law, United States versus Donnelly, quoting United States versus Alfonso, and 18 U.S.C. 2421A says that it makes it a crime to knowingly transport any individual in interstate commerce with intent that such individual engage in any sexual activity for which any person can be charged with a criminal offense. Section 2422A makes it a crime to knowingly persuade, induce, entice, or coerce any individual to travel in interstate commerce to engage in any sexual activity for which any person can be charged with a criminal offense. Counts 6 and 8 charge that the defendant did knowingly and intentionally transport an individual, to wit, Jane Doe number 6, in interstate commerce with intent that such individual engage in sexual activity for which a person can be charged with a criminal offense, to wit, violation of New York Penal Law Code, Section 12020, which is reckless endangerment, and New York Public Health Law 2307, knowing exposure of infectious venereal disease. So he was charged with Jane Doe number 6 for reckless endangerment and knowingly exposing her of an infectious STD. Okay? And also charged with coercing her, enticing her, inducing her, persuading her to travel. Okay. Now, counts 7 and 9 charge that the defendant did knowingly and intentionally persuade, induce, entice, and coerce an individual, to wit, Jane Doe number 6, to travel in interstate commerce to engage in sexual activity for which a person can be charged with a criminal offense. To wit, violations of New York Penal Law, Section 120.20, reckless endangerment, and the New York Public Health Law, Section 2307, which is knowing exposure of infectious diseases. Now, Racketeering Acts 12 and 14 charge the same conduct. Racketeering Acts 12 and 14, as well as counts 6 through 9, also include approximately when and where the conduct was alleged to have occurred. Now, because the indictment recites each element of the federal offense charged and the approximate time and place each charge was alleged to have occurred, and the charges were well pled. So see, it matches the government's evidence matched the corroborating evidence of the testimonies. They proved they proved the case. The charges were well pled. Guilty was what it was. Well played. Racketeering Acts 1 and 3. The defendant also moved to dismiss Racketeering Acts 1 and 3 as untimely, right? Racketeering Act 1 charged that the defendant, together with others, bribed a public employee in or about August 30, 1994, in the violation of the Illinois Criminal Code, Section 5/33-1A and 5/5-1, paragraphs 13. That the Racketeering Act 3 charged that the defendant, together with others, confined Jane Doe number 3 against her will in or about 2003 2004 in violation of the Illinois Criminal Code Section 5 forward slash blah. I can't read that. I'm twisting my words. So the defendant argued that because the Illinois Criminal Code provides for a 3-year limitation period for these offenses, these predicate acts should have been dismissed. But RICO charges are not governed by state statutes of limitations. Federal overweighs state. So whatever the federal law says doesn't even matter because we're going by federal statutes, not state statutes. So moreover, a racketeering act is not an independent count. Instead, it is part of the overarching RICO offense. So it's like the umbrella to the RICO charge. Okay? Give me 1 second, guys. Brittany, thank you for stopping by, Brittany. Thank you. Thank you. And all that stuff you're talking about, girl, it's not even true, okay? Okay? We're over that. Thank you. Okay. Okay. All right. Now it says in the little subparagraph here that the defendant also inserted that permitting the reckless endangerment charge would amount to criminalizing adult consensual sexual intercourse, conduct which is unequivocally legal. And then it talks about the motion number 159 at 9 through 10. And then it says that this is similar to the challenge to the public health law, charges that the defendant raised in his first motion to dismiss in document number 42. And that the allegation in this case is that the defendant had sexual intercourse knowing that he had a sexually transmitted disease without disclosing the information or obtaining his partner's consent to have sex. And then in part 4, it says that the defendant seems to have misstated the charges he moved to dismiss as untimely. And in section 6 of his brief, the defendant argued that the allegations contain count 1 Racketeering Act 1, Racketeering Act 3, Racketeering Act 5 should be dismissed. But the defendant did not discuss Racketeering Act 5 in section 6. In any event, Racketeering Act 5 was timely for the same reasons that Racketeering Acts 1 and 3 were. And the jury found Racketeering Act 3 not proved beyond a reasonable doubt. And it cites the transcript, the trial transcript, page 4765. Now, as it continued to say back here on the top, it said that, okay, so it is part of the overarching RICO offense. The relevant statute for evaluating the timelessness of a RICO action is 18 U.S.C. 3282, which prescribes a 5-year limitations period. And then it cites another case law and another case law. And then in these case laws is that the Second Circuit has held in the statute of limitations context that jurisdiction over a single RICO predicate act confers jurisdiction over other predicate acts. So like I was saying before, federal trumps, no matter what, federal trumps state. And this is a federal trial. Then it cites another case law, and it says thus a prosecution for allegedly violating 1962C is timely if the defendant committed at least one predicate act within the limitations period. And then it says accordingly, and as the Second Circuit has recognized, a defendant may be liable under the 1962 statute, right? C, for predicate acts, the separate prosecution of which would be barred by the applicable statute of limitations. So like I said, it trumps all. That's just what it is. So as long as that the defendant committed one predicate act within the 5-year limitation period, the indictment charged the defendant with racketeering acts alleged to have taken place as recently as December of 2018. So that's how they were able to flip that. Because being that he did commit a crime in the time zone now of 2018, and it's 221, it still falls under that statute of under 5 years. So, womp womp, didn't work. Therefore, like I said, thus the charges were timely. So, Racketeering Acts 2, 7, and 10, the defendant moved to dismiss Racketeering Acts 2, 7, and 10. Each charged the defendant with inducing a minor to engage in sexually explicit conduct for the purpose of producing more visual depictions, child pornography, right, of such conduct in the violation of 18 U.S. 225A, 2251A, and paragraphs 14, 21, and 30. Now, to prove this charge, the government was required to prove 3 elements beyond a reasonable doubt that, 1, the victim was less than 18 years old. 2, the defendant used, employed, persuaded, induced, enticed, or coerced the minor to take part in sexually explicit conduct for the purpose of producing the visual depiction of that conduct. And 3, the visual depiction was produced using materials that had been transported in interstate or foreign commerce. Aha! See? When they were talking about Geronda Pace and how was she charged for transporting, this is what they were talking about. Explicit conduct for the purpose of producing visual depiction of that conduct. And 3, the visual depiction was produced using materials that had been transported in interstate or foreign commerce. So because Rkelly liked to travel with backpacks, with cell phones and iPads and pictures and things, gym bags with videos and cameras and pictures and things, it's called interstate or foreign commerce, traveling with materials. That's what he got charged with Geronda Pace. Carrying materials that had depictions of her. You see how it's very well that you people have to pay attention and really read things and break it down to understand what you're reading. Because you people are out here spinning narratives about these documents and you don't even understand what you're reading. You know what? I haven't done this in a minute, but I need to. Where's my Insta button? I don't know. Wait, no. Where's my, Joshua, did you delete my Insta buttons?
No. Where was it?
It was on the bottom here, the thing that I do, my sound button.
Do you know if they changed like what it looked like?
It looked like a big red button.
Do you know if they changed it?
No.
Because they can do that. Minimize your stuff real quick.
Hold on 1 second, guys. Sorry, guys. This is for all you Reading Rainbow crew.
Friends to know,
my nigga,
ways to grow,
nigga,
reading rainbow.
Here we go again.
I can be anything.
Same old shit.
What? Take a look,
Nigga,
in a book,
my nigga,
reading rainbow. Butterfly in the sky.
Come on.
I can go twice as high.
Let's get it on.
Take a look,
Nigga,
in a book,
my nigga,
reading rainbow.
You think it's a game?
I can go anywhere.
Suck my dick.
Reading rainbow.
This is the shit I be talking about. You think it's a game? You think it's a game? Which I really want. I really want. Ride or die.
For my Reading Rainbow crew. For the Reading Rainbow crew. But why didn't they televise his trial? Because it's a federal trial and they usually don't televise federal trials. I think that was very unfair on his side because we, the public, could have had a better and more fair idea for ourselves. Well, the state trial will be televised, and if you really want to be at the trial, you have to travel to Chicago. If you're not from Chicago, you know, a lot of people traveled to New York and they weren't from Chicago. I mean, a lot of people traveled to New York and they weren't from New York because they wanted to be there to experience it for themselves. But if you can't be there, the best next thing is to purchase transcripts and read the transcripts. It'll be as if you were right there in the courtroom. You'll get all your answers by reading the transcripts. I think it was fair. And this is a very high profile case and it couldn't be televised. You know? All right, so let me finish reading. Okay, so now that we understand that, guys, okay? Racketeering Acts 2, 7, and 10 were pled properly. And as explained in section IB, an indictment need do little more than to track the language of the statute charged and the state time and place and approximate terms of the alleged crime. And the indictment alleged the required elements. Each of Racketeering Acts 2, 7, and 10 stated that the defendant did knowingly and intentionally employ, use, persuade, induce, entice, and coerce a minor to engage in sexually explicit conduct for the purpose of producing one or more visual depictions of such conduct, which visual depictions were produced using materials that had been mailed, shipped, or transported in interstate and foreign commerce. Each also stated the time and place these acts were alleged to have occurred. So inserting that, there is no evidence that visual depictions exist. And then there's the motion 159 at page 12. The defendant confused the standards of pleading with the standards of proof at trial. So unless the government has made what can fairly be described as a full proffer of evidence, it intends to present at trial. So the sufficiency of the evidence is not appropriately addressed on a pretrial motion to dismiss an indictment. And then it cites the United States versus Alfonso. And in there they talk about the government was entitled to present its evidence at trial, after which the defendant could challenge the sufficiency of that evidence pursuant to Rule 29 motion. Now, United States versus Rainier cites that before the trial began, the government had not made a full proffer of its evidence in this case, nor was there a stipulated record. And then it says, see motion 159 at page 3. Thus, so long as the indictment was facially valid, which it was, for the reasons described above, pretrial dismissal was not warranted. In conclusion, for these reasons, the motion to dismiss was denied. So she answered them why everything was denied. First of all, they cited wrong case laws. Instead of citing case laws, they cited news articles. What else? Plus, basically everything they did was a waste of time. They said that something was supposed to be put in on a timely matter. They were out of time. They said that they were out of time, which they weren't, because it was within the 5-year statute under federal law, not state law. State law said 3, federal said 5. This 2018 charge falls right into that, so it doesn't matter. What they said didn't matter. He was convicted of all 9 charges, point blank period. They dismissed what they dismissed. It is what it is. He is now officially a convicted felon, and he will be sentenced on May 4th, and Chicago trial starts August 1st, and that's what that is. So, guys, a little reminder, tomorrow is Friday. Tomorrow, I would like to do a live, and I want all my members to join. It's going to be a members only live. Now, if I can remember for the life of me how I did that, it'll definitely be on and popping tomorrow. If not, tomorrow I would love to have everyone here so that I can give out, we could do the raffle, all right? And I can give out books to those who have Kindles. If you do not have a Kindle, please download Kindle app to your phone, your computer, your tablet, wherever. If you want to subscribe to the Kindle Unlimited, it's $12.99 a month. But other than that, the actual app is free. Also, in my other video called Jane Doe number 9, if you want to purchase the books, if you want to purchase Jane Doe number 9, please refer to my video. It's in the description box. You can purchase the video by going to Amazon.com and typing in Jane Doe number 9. Like I said, guys, for those who are members, I would love for you guys to read along and support our sister and purchase her book. Her Kindle is only $3.99. If you want to purchase paperback, I think it's $15 and $25 for the audiobook. Okay? So tomorrow we will do the raffle as to how many books I will be giving out and the names that will be on the list. For those who are members, if you're not a member, please join the membership, because I will be reading this book only to members. I am not doing it out in public. This book reading is for members only. I promised Lizette I would not put it out publicly. please go buy the book. Download Kindle. Tomorrow, I will be giving away the books. Okay? If I can't do a private members only live, then it'll be public as far as the giveaway, but the reading will be private. So once I do figure it out, if I can't, then we'll start reading. Okay? But in the meantime, go get your books, purchase the book, and download the Kindle app. Okay? Oh, D-Live, that'll be nice. Look at that. D-Live is going to contribute to the giveaway, guys. She'll give a free shirt to a winner. All right. So I guess maybe D-Live, we can make the winner either the first person that I pull out of a hat or the last person. All right, baby. Okay, D-Live. Yes, ma'am. Yes, not all federal trials are televised. Some are. But this was a very high profile case. And you have to remember, there was a partially sequestered anonymous jury. So they didn't really want to televise it for the public. Because remember, Rkelly was accused of intimidating witnesses and also intimidating or bribing a juror back in 2008. He paid someone. Don't you remember John Doe? John Doe, I think number 2, had admitted that he bribed the juror in 2008. Yeah. Let's not forget that, guys. Cheers. Granny, you have to reorder what, Mama? You have to reorder the book? Why you have to reorder? Oh, to Larry, Mama? Oh, yes, baby, because remember I forgot you said something about sending him a Kindle. You can't send him a Kindle. You're going to have to send him the paperback, baby. Yes, come in. The books went to you fucking loca. Granny, what you doing, Granny? Ruby. Oh, no, that's Sarah. Hi, Sarah. Ave Maria, Granny. I can't believe you did that, loca. Oh, my God. Oh, Lord. Well, guys, don't do what Granny did, please. Please make sure you correct the delivery address. Make sure you check everything before you go forward with your order. Well, Rkelly, he put in a lot of work to be treated like this. He did. He put in a lot of hard work to abuse women in a span of 30 years. And now he has to sit in jail for however many years Judge Donnelly decides to give him. Sexy. My husband just shaved some of his face. Hey, Tasha. Hey, Ruby. There goes my girl. Charisse. Granny. Right, Shalisa. A lot of federal courts don't televise. They don't. It's usually state. It's usually state that does it. But if they do, they do, because they have. You know, you guys could correct me if I'm wrong and prove me wrong. But 9 out of the 10 times, it's state that usually televises, not federal. But if they do, they do. But this was a very high-profile case, and they were not going to do that. But the state case for the sexual assault trial, which will be after the Chicago federal trial, they will definitely televise that. Floyd trial was state. Okay, thank you, Mama. Thank you, Miss Ray. Thank you, baby. Thank you for that. See, we got some people up in here that are on their shit. You can't fool us over here in the state of Minnesota. Thank you, Charisse. Well, I don't know. Let's see. I'm gonna go with your theory. I'm gonna do what you say. Okay? I'm gonna do what you say. No, it was a state trial. Wait a minute. Wait. No, okay. Convicted in April on state murder charges. Pleaded not guilty on Thursday to federal charges. Okay. One separate federal trial. Oh, so he separated the trials. So it was a federal trial. It was a federal trial. Thank you. But even at that, that's irrelevant. It doesn't even matter. It doesn't even matter because, like I said, you get the transcripts, you read the transcripts, you will find out for yourself. Now, what I was thinking of doing is I have this account called Scribd. And in this account, I can download documents. Now, what I could do is I can always download the transcripts to my account, my Scribd account, and I can always put it in my description, and you guys can go to the Scribd account and you can download the transcripts for yourself and check it out. I could always do that. You know, the trial is over. Well, the transcripts really aren't terrible. It's the people that read it. It's the people that are reading it. They're not reading it exactly right, or they're not reading it verbatim. They're skipping words. They're adding words. This is why. So if you go to my brother Atmos Love Zone, if you go to his page, he did all the readings. You can go. A matter of fact, I think he should put that in a playlist. Atmos, if you're listening to me right now, I think you should put all of the Rkelly transcript readings into a playlist in order so that, people can get a chance to jump into your playlist and check out the transcript reading. It's crazy. So, yeah. So, guys, if you are not a member and you would like to join the membership, it's $1.99 a month. And you get little perks as far as emojis, just putting little emojis in the chat. See, like this. Put little emojis in the chat like this. This is just an example. Right, Nicole. Right, Nicole. Thank you, Mama. Thank you for that. So you guys, and as you grow with the months, like you start your first month and you get into the second, the third, the fourth, the fifth, and the sixth. Once you get into these months by months, then the badges will change. So your first badge next to your name should say knowledge is power. And then when you are in the second tier, which would be the second month, you will have badges next to your names that say seal of approval. Okay? And as the months go on, your badges will change. Well, you know what? I did a lot of research, honey. Let me show you something. You know what? Tim, let me just show you an example of the research I've done. Let me see if I can share my screen. Hold it. Let me see. Okay. All right, now you see this window, right? See the window on my screen? Oh, where is it? All right. Now here I have, you see this one that's highlighted? This is the Northern District of Illinois RSK case. Okay? This is all the paperwork that I have taken out of Pacer since February of 2019. Or whenever it was, he got July or February, whenever it was, I forgot. You see, look. Transcripts, Rkelly fan letters, his bench warrant, protective order, a bunch of other stuff, transcripts, responses, motions, indictments, stuff about Daryl McDavid in here. And goes on and on, see? So I got this much here, right? Then we have here the Eastern District of New York R. Kelly case. And here I have all these things here. You see? You see? I paid for all this paperwork. None of this was free. I've done spent a lot of money researching on R. Kelly. Okay? Then we got over here, what's the other one? Then I have the transcript. Transcript files. These are files of the transcript from the actual trial. See that? Right? Then I have here other things that are referenced to R. Kelly. Okay, I even have his background report. I have his wife's background report, his daughters, Daryl McDavid's. Yeah. Yeah, I had June Brown. I don't know where the hell it's at. It's in here somewhere. Let's see what else I got here. Oh, fact sheets. Fact sheets about the RICO, obstruction of justice, a manual for an annual report about sexual violence, another one about Chicago's reports on sexual assaults and rape, a bunch of things here on facts, okay? Statistics and things of that nature. Where's the other one? Okay. Then we have here, thank you, Karen. Thank you, Mama. Then we have here, Don Russell. I paid for all of this. This is not free. All Don Russell. Let's see what else. Oh, look. Now in this file, I have a bunch of lawsuits that were against R. Kelly. Look. Wow. I got a couple of lawsuits here. What do you know? I do research. What do you know? Wow. Isn't that something special? Thank you, Rockin'. Look, Michael Williams. Michael Williams documents. I got some of that. Let's see, who else? Who else? Let's see. Okay. Then I got, let me see, espérate, where's the other one at? Oh, is this one here? I got a couple of recordings here too from articles that, not articles, podcasts that people have done, spoken about R. Kelly. Let's see, what else research have I done here? What else? What else? Okay. And then I got pictures of his trial, things of that nature. Then let me just show you something else. Hold on. Let me show you something else. Espérate. Let me show you something else. How do I do this here? I have to hold this first. Let me show you how much research I don't do. Okay. Let's see, restore. Okay. Oh, yeah, here we go. Okay. Will it show it? Yeah. All right. Okay, look. Now. Oh, I have to share my screen with you. Hold on. Let me show y'all. Let me just show you. Okay? Okay? Tim, so I can just show you, all right, puppy? Check it out, okay? Check it out. You see this here? These are all bookmarks, right? Let's see. We talk about Stockholm Syndrome in here. I have information about Don Russell's Indie Build Company. Let's see. Stuff about narcissists, STD cases. I got stuff about Lisa Van Allen. The FBI records. Okay, no, that's big small stuff. Look, R. Kelly's manager breaks silence, my pacer, a whole bunch of shit here of more R. Kelly stuff that I just finished wiping out a lot of R. Kelly articles out of my mobile bookmarks. And now I have more in here that I'm going to have to take out and put into my folders. You see that? You see how it's just flowing? You see how it's flowing? This is my mobile bookmarks articles that I have copied, pasted, read, saved, all on R. Kelly. Look. R. Kelly, precious teenager. R. Kelly became angry. R. Kelly made girlfriends fight each other. R. Kelly accuser says singer kept a gun. R. Kelly spectator tells witnesses. R. Kelly victim said he gave her herpes. 5 egotistical personality traits. R. Kelly and Aaliyah got married. Alex and Ernie Isley on Aaliyah stuff. All this. Witness testifies and R. Kelly paid $200,000 to settle STD suit. All of this is R. Kelly too. Now, let me go up. Because this is mixed. I have a lot of mixed things in here. But a lot of it is R. Kelly. Okay? That's not just it, y'all. That's not just it. There's more. Hold up. Let me surprise you. I hate when people say, I don't do research. I don't look up nothing. I don't read. I just go by what bloggers say. Sorry, that's not me. Now, here you go. You see this one right here? It says R. Kelly Files. This is the R. Kelly Files right here on this side. You see this where my arrow is? Look. You see how it's scrolling? That's all R. Kelly. And it's still going. I've got stuff from 2008 articles, 2002 articles, 1991 articles, 1998 articles, 1994 articles. It's still going. Do you see it's still rolling. It's still rolling. This is a whole file of R. Kelly. Everything in here is R. Kelly. Everything. And it's still rolling. Now tell me I don't do no motherfucking research. Then here I have rules of law. A whole section on law. It's not a lot, but it's enough for what I needed to know. And there's more in here in my other in my mobile bookmarks as well. And I have some stuff on Aaliyah, which I got to extract a lot of other things out of my mobile bookmark. I got stuff on interesting topics. You know, Epstein files. I got Bill Cosby, a little bit of Bill Cosby. Stuff on health. Assault and violence. Look at all the stuff I got on assault and violence.
He ate the girl's heart.
So yeah,
Remember when
I do a lot.
Like
I do a lot.
When she returned
Trust me when I say. And thank you so much, guys. Oh, and the stacks of paperwork. Hold up. Espérate. That's, girl, I'm glad you brought that up. And the stacks of paperwork, which I'm not going to bring out, but it's in my file folder. I actually have a cabinet file folder with a key, with a lock. Okay? Yes. File folder. Okay? I do my shit. All right? Just so you know. Cheers. All right. Thank you, Granny. Thank you. Hey, Mississippi Mama, Mama, Mama. MISSISSIPPI. Hi, baby. Okay? I work, damn it. I work. You could ask my husband how long I be on my phone, on my computer doing research, reading. And don't get me started. Wait, hold up. One more thing. One more thing. One more thing. One more thing. Okay. And one more thing, guys. Let me share this with you. Okay.
I like this year.
Now, guys, for those who don't know how to join the membership, you can join the membership right here next to my name, Divine Light. It should say join. If you go on your phone or your tablet, it might be the join button, might be underneath my name. Okay? And let me show you one other thing. Okay? That I have. What the hell? What's going on here? Okay, here it goes. Okay. Now in here, this is my watch later section of my YouTube. And I usually put a lot of things in here. And I have 3,736 videos in watch later, right? I have a lot of things talking about Rkelly. Now, I even have a whole section for Rkelly. And in this section, I have 795 videos talking about Rkelly, interviews, things of this nature. Okay? So, yeah, I do a lot of research. A lot of research. Okay? A lot. So, I don't want anybody to ever say that Diva don't know what she's talking about, or Diva does not do research, or Diva does not bring the truth. Because all of that would be lies. Okay? People don't know me. You know, it doesn't matter if it was televised or not at the end of the day. What matters is if he's guilty or innocent, right? That's what matters. Who cares if it's televised? We really don't care. Okay? So, I'm going to let you guys go. Thank you guys for your donations to the Super Chat. Thank you, ladies. And for those who donate to my Cash App, thank you very much. Or my Zelle or my PayPal. For those who do and have, thank you for supporting the channel. Y'all already know that helps me pay my bills for Pacer, my StreamYard, my internet, ink, and anything else that needs to be paid that pertains to my channel. So thank you very much, guys. And remember to join the membership so you can be part of Diva's Book Club. And we could do read-alongs, and I will be giving giveaways there. You're very welcome. And please don't forget to go to Amazon.com. If you don't have Amazon, please purchase Jane Doe number 9. It's on sale now. Purchase your books so you can read along. Okay? No, you know what? We don't have his versions of events. You're right. We don't. And you want to know why? Because he won't take the stand. When he takes the stand, then we will believe his versions of events. Other than that, he's a liar. Known to many people that he's a manipulator, he's a liar, and that's what it is. His credibility is shot too. He don't have no credibility. Okay? He don't. He don't. Hey, Charlotte. What's up, mama? All right, Tim. No, you know, these videos, the only videos that the public has seen ever are the videos that were out back in 2001. Those are the only videos that the public has ever seen to show Rkelly in action and just how wonderful of a man that he is to be peeing on a 14-year-old girl in her mouth. Okay? Okay. So, and I saw that tape. I saw that. He was in the camera, all the way in the camera, his whole face in the camera. He was adjusting the camera, the lens part. He's fixing the lens part, and he's siding it, and he's moving it around, and he's grinning, and he's smiling. And it's Rkelly. It's him. His whole face was in the screen. Now, this video that's out there.
What are you talking about? That was his lookalike.
Right, it was his lookalike. It was his brother, Rkelly. Right. No, it was Damon Pryor. Right. No, it was Levi. It was Levi. Levi did it. Oh, Lord. I cannot. And like I said, that video that's out there in public, they cut out the part where Rkelly started the video with his face all in the camera. They cut that out. People did what they did for a reason. That's why they did what they did and how they did it. They didn't show him all in the camera. Because for those who saw the video, I know what I saw. And I saw Rkelly adjusting the camera. His whole face was in the camera. See his big lips, his monkey ears, everything. His face up close and personal like this. Bow in your face. Right, he was adjusting the camera. At first, before he went to sit down, he was adjusting the camera. You see his face right in the camera. He's fixing it. He's twisting the lens part. Like he's trying to get it focused and shit. And he's turning it sideways, like to make sure it goes into the right angle to where he's gonna sit. And then after that, he adjusts it. He's like, okay. Then he steps a little bit back. He's like, okay, I think, yep. Then he goes and he sits down. And then he looks in the camera and he starts doing that move. And he's looking in the camera and he's like, yeah, let me see. Yeah, let me think. Yeah, yep, I think this is good. All right, let me go get her. And what does he do? Comes back with the girl, Rashonda. She sits down. He gives her a bill. We don't know what it was. It was probably $100. Gave her a $100 bill. She says thank you, smiles at him. He walks off the camera, comes back to the camera, and sticks his dick in her mouth.
What?
Okay? Just like that. So, right, you couldn't miss his peanut head. His body was slim. Those guys are bigger than RSK. That's fact. That's a fact. Babe, Tim, Aaliyah was lying, just like Rkelly. Listen, they had a settlement. They went to the table and made a settlement so she could leave. Rkelly, she got the marriage annulled. And then she got it expunged from her record. That's how desperate she was to get Rkelly's name away from her.
You and your sister start first.
Okay?
I want to eat, right?
Yes, thank you.
Too many in there. No.
Just do half. I'm doing some too. I'm going to be cooking, so let's go. No, because I don't have the video of that. I wish, you don't know, for some reason now in this day, I wish I had the original video. I wish I had the VHS because I would show you. I would show you that first part. I wish I still had that video tape because people chopped up that tape. The full tape is like 40 minutes long, 45 minutes long or some shit. The full video is about almost an hour long of him with different girls. Yeah, baby, but the clip is only showing him sitting down. Let me see if I could espérate. Let me show y'all what I mean. Hold on. Let me give me a second. Let me go to my yeah, let's see. Oh, do I have to sign in? Oh, I think I gotta sign in. No, yeah. Okay. All right, give me 1 second, guys. And then after that, I'm gonna after this, I'm gonna end the live because I gotta attend to the family. Y'all know already. Oh shit. Oh no. Joshua, you're messing up my A and you're messing up this keyboard here.
Because I use it too much.
Yeah, because you want to put your hands on it.
I have to hold it down.
I get it. Damn, I need some more juice. My throat up. I'm starting to lose my voice, guys. I'm gonna have to stay off of YouTube for a couple of days. Give me 1 second. Davina, I need you to wash some dishes, Mama. One half. So you gotta wash the other half. And then I'm gonna cook. There's not a lot of stuff in there. Okay. Sorry about that, guys. Let me open up my okay photos. Thank you, babe.
Mother says she likes India. I was like, well, you didn't tell me that yesterday. You said mata.
Oh, she wasn't specific. Okay.
So what?
Okay.
Listen, you gotta be specific. Right, people?
Yes.
You want something.
All right. Where's my what happened to my? Uh-oh. Where's my mouse? My mouse turned off. Why?
Sometimes that happens and you have to plug it back in.
Oh no, that should not be like that at all.
And that's been happening with the keyboard too.
Uh-uh.
I have to plug it back in and out.
I'm gonna have to get all new stuff.
Wait until the internet's set up. But the thing is, I can't play Minecraft when the internet does get set up. Because I have to buy it again. And I don't remember my Minecraft password.
Okay.
Oh, I know, it's your email for the strawberry.
Yo, can I blast my radio? I'm ready.
Not yet.
It's funny how Dad cries about me having my stuff loud, but when I ask him to lower, he doesn't.
I mean, it's his girl.
Yeah,
Yeah, no.
still. That means I shouldn't lower my stuff.
This is our estate.
Ty, I don't know what I did with it, babe. I don't know what I did with it. But if I could only play, if I could only show you guys this video for those who never saw it, if I could show you a portion of a video, you guys would be amazed. Disgusted is the word, you know. Okay. I know there was no sound. I was on mute, mommy. I had behind the scenes things going on, you know.
Oh, yeah. Let me get it. Oh, yeah.
Uh-oh. What's this one, Ty? What's this, Ty? Let me see. Did you send it? Did you send it to me through text, Ty? Oh, shit. What the hell?
Let me get it. Oh, yeah.
See, my...
Shut up.
David.
I know that meme. Someone's done that before.
Ave Maria.
They scream, can I get a oh
Now my phone just went kaput. I don't know what happened.
Let me get oh, yeah.
Oh, my phone's at 18%. I need to charge.
yeah? And you don't sound nice.
It was the clip I watched. Okay, baby. Let me,
It's oh yeah.
I know, mama, but you know what? That clip,
Can I get a oh
I
yeah?
chopped that clip up.
Oh, yeah.
Don't mimic him.
I did. And I don't know where's the other parts. I must have deleted it. You know, I do stupid shit when I'm asleep. Okay.
That looks like your dad.
Thank you for the Cash App, ladies.
Oh, we got quiet again.
Thank you, ladies. Thank you, thank you, thank you. Hey, Quisha. What's up, mama? Okay, let me see if I can find it. Hold on. Let's see. Let's see here.
Your balls. Got him.
Look, my video's in Google, guys.
No freaking way.
Yeah, look right here. The video right there.
Bullshit.
Right here. This is the Google.
Mom's videos in YouTube. You can use the Tech 9. Listen, so you know how we don't have the
It's not showing, man. I can't find it, y'all, right now.
Listen, you know how
Well, that's all right. Oh, wait. Let me see, Ty. Hold on. Let me see if I could do it this way.
I can use the crossbow. So you should be able to use it.
Okay.
I'll show you. That's the G11.
No, wait. How do I do that?
Remember the G11? Call of Duty 1? The black, 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 black. I didn't forget.
Okay, see, that's the thing. I was trying to grab it from the chat, but I can't, Ma. It's not letting me. It's not letting me copy and paste it. It's telling me all these other things. What is a BBC player, Mama? What's that? Sarah. Okay. Let me see if I could like I said, send it to okay. Oh, you know what, Ty? Put it in the messenger. I can open up my Facebook from here and do it. Joshua, you did your part of the dishes?
Not yet.
Please do, because I'm about to take out the burgers.
I only have the cups and stuff. You should take out the burgers.
I'm taking out the burgers right now. And then I'll be finishing my live in a little bit. A couple more minutes and then I'm done, okay? Oh, here we go.
And on the roof there.
I actually have 2 other burgers here. All right. Let me see. Ty, you put it in the chat between me and you, or the okay? Okay, I got it, Ty. I got it, Ty. I got it, Ty. I got it, Mama. Thank you, baby. Next time, Mama, that's how you do it, babe. When I'm on my live, send it through Messenger so that then I can open it from here. Okay, hold on. I'm gonna mute it. There's no need for us to hear it. Okay, let me share my screen with y'all.
I'm on the roof. Here, take that money.
No. Where you going? Going back to home.
Let me. Okay.
I caught that nigga that was on the roof. And I lost the money. Hey.
Okay.
13 grand, purple.
Thank you, Ty. Okay. There we go.
My ammunition box, all purple.
Now, as we all know, that's our Smelly, right? This is not Levi. It is not Damon Pryor. It is not Rkelly. It is R fucking Kelly. Okay? Okay? Him right in the camera. He's looking right at you and he's got shades on. That is Rkelly. Nobody else. That is Rkelly. This is Rkelly right here. You see it? Right here. Now, before he sat down here, he was in front of the camera. Before he moved to sit down over here, he was in front of the camera adjusting it. The lens, moving it, making sure that it's on the tripod right. Then he went and he walked over and he sat down. Then he started doing these things. He's like, well, if I move over more this way, yeah, we can. Yeah, all right. Wait. Yeah, I think, yeah, this will be the spot. It's perfect. This is perfect. Okay? Okay? This is him adjusting the camera. He didn't put this date stamp on it, but he's got the minutes and hours and stuff on it. This is Rkelly in the Colorado room. And that was Rashawn the Landfair. Poor little baby. This is him. This was in 1998. Okay? So, terrible. And this is your boy. And that is Rashawn the Landfair. Look at how little that little girl is. Her hair, her face, you could just tell. I have another video, but I cannot show that video. I cannot show the video, and I really would love to. Right, you see her little head? Her little ears? Guys, I have a video that it don't look like Levi to me either. Okay? This is the girl. Poor baby. Poor baby. That's Levi. That's Levi, y'all. That's Levi. They're so retarded, man. Come on, man. That's Rkelly. Give it up. You know that's Rkelly. He's guilty as hell. He's been convicted. He will be convicted again. And that's it. That's all. And it's not Carrie. It's not Levi. It's not Damon Pryor. It's Rkelly. Point blank, period. So now let me see something. Let me see something. I'm gonna see if I can find let me see here. Let me see. Oh my God, this is a funny ass video, y'all. Let me see. Wait. Okay. All right, wait. This is a funny video, guys. I'm gonna show you something funny. We need to laugh a little bit, so I'm gonna show y'all something funny. Oh man. All right. This is Terrell Green, and he's on Facebook. I don't know if he has a YouTube channel, but he's on Facebook. Watch.
Oh shit! What is that?
Upstairs in my building. It's like he knew I'm exactly right there. That's fine.
It's called You Gotta Watch Your Kids.
Bruh.
The things that kids do.
Really, nigga?
Look like a kid was tense.
Oh my God, wait. Let me go back. Close it. Why is it not closing? Okay.
Oh
Okay.
Dishes?
This one is, it's too much going on in my neighborhood. Hey, truth be told, what's up, Bobby?
Bruh.
Yo. Oh man. Oh, that's gotta close. Hold on. Wait, how do I? Oh, I gotta go here. But there's something I wanted to show you. Give me a second. Let me look for it. I've got a lot of shit here.
Yo. Look at the two old ones. Look at the two old ones and look at the new one.
Oh, that's because they got frostbite. How you call that? Freezer bite. Yeah. Um, where's that page? I got a lot of stuff here. I'm just trying to find. Okay, hold on.
Yeah, it's cold in here.
Yeah,
I'm about to turn on the oven.
yeah. Okay, it should be somewhere around here. It's okay.
Easier for them. Right. And what they've done, I'm sorry to be.
Okay, hold on. Okay.
Easier for them.
Right.
What they've done, I'm sorry to be so long-winded, but what they've done is they've taken a series of otherwise consensual or misdemeanor acts, for the most part, and said, we're going to elevate these into some kind of a felony offense. So, for instance, they've taken some New York State misdemeanor crimes and said that these crimes are sex crimes. They're misdemeanor sex crimes.
Okay.
And the RICO Act just broadly refers to sex crimes. It doesn't differentiate between felonies and misdemeanors. So they're elevating these misdemeanors. It's like I said, it's a bastardization of the law. Easier for them.
Right.
And what they've done, I'm sorry to be so long-winded, but what they've done is they've taken a series of otherwise consensual or misdemeanor acts, for the most part, and said, we're going to elevate these into some kind of a felony offense. So, for instance, they've taken some New York State misdemeanor crimes and said that these crimes are sex crimes. They're misdemeanor sex crimes.
Okay.
And the RICO Act just broadly refers to sex crimes. It doesn't differentiate between felonies and misdemeanors. So they're elevating these misdemeanors. It's like I said, it's a bastardization of the law. Easier for them.
Right.
And what they've done, I'm sorry to be so long-winded, but what they've done
So Rocky Bivens said he never saw underage girls with Rkelly, but yet knows that Aaliyah was underage, right? And just make that make sense, right? He said it was love because he was doing for her, she was doing for him, and he was doing for her. So that made it all right for them to be together because he loved her. He was infatuated with this little girl. That's what it was. He was in lust. In lust. Yeah. Let's continue.
Was it?
So he said he heard there was a ceremony. Yes. Hey, Patricia. Welcome, welcome. We're against Rkelly. We want him in jail. Sane. Hi, Sane. Oh, shit.
Yeah, I'm about to throw this in the garbage.
What, baby? Okay. Sane, that is funny, Sane. Yes, facts. Patricia, I hope you were against Rkelly or you're for Rkelly, but it's okay if you're for Rkelly. Oh, good, you're in the right place. Awesome. Welcome, sister. Welcome, welcome, welcome. Welcome, Patricia. You're right at home. I am Diva Divine Light. This is my platform. And we are OCOVE. We are known as OCOVE, and OCOVE stands for One Color, One Voice, which is OCOV. And we are not for Rkelly. We are for Rkelly going to jail and never coming out ever again. Yes. Lady Eugenia, what's up, mama? Yeah, exactly. Let me continue. And welcome again, Patricia. Hope you can join the membership too. I'm going to be doing private book readings, and we're going to start with Jane Doe number 9, Lizette Martinez's book. If you get a chance, that would be awesome if you can purchase the book. If not, if you join the membership, you will get a chance to win a book because I will be giving away some books. And I will start tomorrow. I will do the raffle tomorrow. So welcome, honey. Welcome. So now he confesses that he was actually at the wedding. So he was the other guy that was there with Demetrius Smith. Remember, Demetrius was like, I don't remember who it was, but I know it was another guy there. Yeah, it was Mr. Bivens, Demetrius. Do we have to refresh your memory?
When it came to sex, it was sex to Robert.
Despite the age.
All right, guys. I will catch you guys later. Yes. Oh, thank you, Patricia. Thank you and welcome, welcome. There's a blue button there that says join. You can join, or if not, I believe it will also be in the description box of the video. All right, so guys, I will catch you later. I'll see if I will come back later on and do something else with y'all. Okay? I love you guys. Please don't forget as well. Y'all know what to do already, right? Leave your comments below in the video, please. Subscribe if you are not subscribed to my channel. Make sure you hit the notification bell on the side. Put it on all so you can get all my videos as they upload. And thank you for everyone who joined the membership. And thank you, lovely ladies, for the cash apps and the super chats. Thank you, thank you, thank you. And I will see you guys. Don't forget to hit that like button on your way out. Peace.